Hi guys, welcome back to another podcast. We are back with Neil McKinnon for a second episode. He was actually in episode 5 where we discussed timelines in the property transaction process. This time we're going to be going through Voetstoots and everything associated with that. And yeah, for those of you who don't know, this is Neil McKinnon from Hammond Pole Attorneys in the Fourways branch of their office. So yeah, Neil, if you wouldn't mind introducing yourself and Hammond Pole.
Awesome. Thanks, Will. Thanks for having me back. Good to be back with you guys, and always only a pleasure to share information with you. So I'm Neil McKinnon. I'm from Hammond Pole Attorneys. As you say, I look after our Fourways division. I'm in the conveyancing department, which is our Fourways division is a smaller office of our bigger firm. I can give you a little bit of background. Hammond Pole Attorneys is quite a large firm. In fact, we're the largest firm on the East Rand. We've actually won a number of awards in terms of the best law firm in Ekurhuleni for the past 3 years. We're very proud of that. But essentially, we employ 500 people. We've got a call center where we employ about 200 people. And then, of course, we've got a litigation department. We pride ourselves on our conveyancing department, which employs about 60 people. And we're proud to be associated with all of the major banks. So we're on all of those panels, and if I may say, we're a powerhouse when it comes to conveyancing. So good to be with you, and look forward to working with you again, Will.
Yeah, excellent. So definitely no better firm to be working with, especially when it comes to something like Voetstoots, which I think is misunderstood by a lot of people. So I think this episode in particular will be very helpful to a lot of people going forward. So with regards to that, there will be a breakdown of 9 sections that we're going to quickly go through. So basically it'll be what is Voetstoots, then the duty to disclose, the duty to inspect, patent and latent, buyer's recourse, warranties and misrepresentations, defects after sale, late discovery of defects, and finally estate agent's responsibility. We're going to kind of cycle through each one of those, and then I'll timestamp each section for people that want to go specifically to a certain topic, just to make that a bit easier. So yeah, Neil, let's start on the first one, which is what is Voetstoots?
Okay, so Will, first and foremost, our law in South Africa is based on the Roman Dutch principle. And Voetstoots is an aspect of our law which is developed from the early days of law. If you can imagine the old Roman times where people had to go into the town centre and declare that they were going to sell something. Effectively, what would happen is that if you wanted to sell your wheelbarrow, you would go into the town centre and publicly declare to everybody there that you are selling your wheelbarrow, and the person buying it would also then declare that he's taking ownership of it and that he's making payment. The problem came in when there were hidden aspects or hidden defects, if I could use that word loosely at this stage. But Voetstoots really boiled down to a situation where guys were selling livestock. And although one could see the livestock and you could see how many chickens or cows or whatever you're buying, you couldn't actually determine whether they were carrying diseases and if they had health issues. So they came up with an aspect of law which protected the seller against a scenario where some of the livestock died because of a disease. And that's where the Voetstoots clause came in, where it protected the seller from a situation later on where the purchaser had an issue where the livestock were dying. And that has been carried forward over the years and now commonly applies in terms of property transfers, where a property or any item sold, second-hand for that matter, where it's sold and the purchaser later on down the line realizes that there's now issues with this property. So commonly where a seller had sold a property and the purchaser realized that there's a cracked ceiling or a broken window or something like that, he wouldn't be able to then go back to the seller because he's bought the property Voetstoots or by the test of the foot, so to speak. So that's just the history of Voetstoots in terms of protecting the seller, and we'll get more into that in a few minutes.
Okay, excellent. Yeah, so we, after that definition, we can move straight on to the second part, which is the duty to disclose.
Right, so we'll essentially, as I mentioned, the seller has a duty to disclose defects. And when I mentioned the Voetstoots element of law, it protects the seller from situations where the purchaser identifies issues with the property down the line. But to recap, as I mentioned, the seller wouldn't be able to rely on the Voetstoots clause where it deliberately concealed something, and I'll get into that in a few minutes. Having said that, when selling a property and when it applies to property sales, the seller has a duty to disclose defects which are latent. So something that's not obvious to the purchaser. The purchaser viewed the property and identified that there's a crack in the floor or a wall. That would be something clearly visible. But if it was a latent defect that the seller knew about, in terms of a leaking roof or something like that, or something that he was aware about which is not clearly obvious to the purchaser, the seller has a duty to disclose that. And that's normally contained in the mandatory disclosure form by agents when the property is sold.
Okay, great. So I suppose duty to disclose mostly leans on the seller. So we can move straight on to the purchaser's responsibility, which is duty to inspect.
Yeah. So in as much as the seller's got a duty to disclose any defects in the property, I think it's also up to purchasers as well. And that's where I suppose purchasers will get some benefit from these podcasts. Is that they're alive to the fact that latent defects are there, and the seller might not disclose these defects to the purchaser. So that would then put the ball in the purchaser's court to make sure that when they are buying a property that they're fully inspected. And I suppose your purchaser would be guided by agents such as yourself to take them through the property and fully inspect it. Obviously, there's some issues that might not be clearly obvious to the layperson, but it's a good idea to take your client through the property, have a look at the pool, ask questions about the roof, and do a full inspection of the property in terms of rising damp, cracks in the walls, and especially behind furniture. It's beneficial for purchasers to simply ask these questions on inspection. Are there any issues which I cannot see sort of behind a wall unit or behind furniture that might be hiding this latent defect?
Okay, great. So we'll move swiftly along to the fourth one, which I think is very often misunderstood by a lot of clients and even agents at some point, the difference between patent and latent.
So, well, as I mentioned, I've spoke largely about latent defects in the previous discussion, but essentially the difference between a patent and a latent defect is a patent defect, firstly, is obvious. It's something that's visible on a normal inspection. So if the purchaser had gone around to view a property and there was a crack in the wall or a crack in the floor, in the walkway, that would be a patent defect, something which is clearly visible. And on inspection, if that was clearly visible and the purchaser hadn't raised an issue with that, he wouldn't be able to then have a claim against the seller down the line because it's a patent defect and was clearly visible to the naked eye at the time of inspection. A latent defect is something that's not immediately obvious. It's not immediately visible to the naked eye. So the most obvious example would be a leaking roof. A purchaser bought a property during the winter months when there's no rain, and then 6 months later when the storms arrived and the roof started leaking, that would be a latent defect. The difference there would come in, and we'll get into this in a few minutes, but the difference would come in as to whether or not the seller was aware of the defect in the roof. To recap what we've said early on, if the seller was aware that there was a problem with the roof but didn't disclose it to the purchaser, then he wouldn't be able to hide behind the Voetstoots clause and would be liable to the purchaser for those defects. If it was something that the seller wasn't necessarily alive to, or didn't realize that there was a problem with the roof, then he would be able to hide behind the Voetstoots clause. And if the purchaser wanted to impress upon on the seller to pay for that, the seller would have to prove that he didn't know about the leaking roof. As I've said, it's the seller's responsibility to disclose all of these defects. So if you are selling a property and you are aware of certain issues with the property, an electrical issue with one of the plugs, rising damp in one of the rooms, you would have a duty to disclose that. And in as much as I spoke about an inspection of the properties, some purchasers can go as far as to get somebody to come and inspect the property from a professional point of view. I think that from that aspect, the purchaser would be responsible for that, and that would be something that would have to be arranged with the agent and the seller to arrange for a professional to come in and inspect the property. Well, as you know, in a property transfer, the electrical installation in the property, the electrical appliances need to be inspected by an electrician for the purposes of providing an electrical compliance certificate. So that's one aspect that would be inspected. And if there are issues, in order to get that electrical compliance certificate, the seller would have to pay for that and resolve it. But certainly the purchasers do have a right to inspect the property fully, and if they deem it necessary, to have a professional inspect the property. But I think that would be a cost associated with the purchaser.
Okay, excellent. So yeah, moving to the fifth point, which is buyer recourse.
Yeah, so well, in a situation where there are defects with the property, if we are faced with a situation where the seller didn't disclose that there's a leaking roof and the purchaser identified that during the raining months, then what would happen is the purchaser would have to employ a contractor to attend to the repairs. He would have to get a damage report, and if it's still in the early days of transfer, he would be able to correspond with the seller and request the seller to take care of it. If transfer has already taken place and the seller denies that he's responsible, then the buyer's only recourse would be to effect the repairs or to pay the contractor to attend to the repairs on the roof, and then he would have an action in terms of law. He would have a civil claim against the seller for the costs that he's incurred in repairing the roof, or he would have a damages claim against the seller down the line. It's not always practical to set aside a sale of property, so unfortunately the purchaser would have to fix the roof himself and then approach an attorney to issue summons against the seller. And then, of course, as I mentioned earlier on, the seller would have to defend himself and prove that the Voetstoots clause applies, and that he would be able to hide behind the Voetstoots clause, or prove that he simply didn't know that the defect was present. But as I mentioned, the purchaser does have a claim against the seller, and the only recourse that he would have once transfer has taken place is to follow a civil claim. I have had situations where defects have popped up during the transfer process. So in other words, in a situation where the purchaser has taken occupation of the property and has identified a number of defects in the property. I've had it before, where purchasers have identified additions to the property that have been done incorrectly. Even had a situation where plugs for TVs and other electrical points have been installed contrary to the Occupational Health and Safety Act, and there were just massive problems with the house. And because transfer hadn't actually taken place, we were able to then cancel the contract, and the purchaser was able to just simply hand the property back to the seller. Unfortunately, that does create certain disputes because the seller has an expectation that the purchaser will continue with the agreement, and the purchaser, as far as he's concerned, will be cancelling the contract. So there might be a dispute as to repayment of the deposit, and it would be pretty much the same civil claim that I spoke about with the buyer's recourse early on.
Okay, great. I think that covers that quite thoroughly in terms of the rights of the purchaser. So we can move straight on to warranties and misrepresentations.
Yeah, well, so when it comes to warranties and misrepresentations, very important to understand that a seller cannot escape liability by relying on the Voetstoots clause if he's fraudulently misrepresented something to the purchaser. So it goes without saying that if the seller was aware of a defect in the property, aware of a swimming pool that leaks or a pool pump that's on its way packing up, he has a duty to disclose that. And if he failed to disclose that, then it would be a fraudulent misrepresentation, and the seller wouldn't be able to rely on the Voetstoots clause. The same situation would be if the purchaser directs a straight-out question to the seller asking, are there any defects? If the seller's answer is no, but in fact that he knows about it, that would be a misrepresentation, and he wouldn't be able to rely on the Voetstoots clause.
Okay, so we'll move straight on to the seventh point, which is defects after sale. Who is responsible for damage done to the property after the sale contract has been signed, but before registration takes place?
Well, until the date that transfer has taken place, strictly speaking, the seller is responsible for damage to the property. So because the seller is still the owner, before transfer has taken place, he assumes the risk in and to the property. But the situation might change where the purchaser is given occupation of the property. And this is catered for in various offers to purchase, where the purchaser then moves into the property and transfers delayed for whatever reason. At that stage, the purchaser would be responsible for damage to the property. So in other words, the purchaser would accept the risk in and to the property from the date of occupation. So the responsibility does shift depending on the circumstances, but strictly speaking, before transfer, the seller is responsible unless the purchaser has taken occupation and he's assumed the risk. And that would be covered either in the offer to purchase or in an addendum that the parties could enter into post signing the offer to purchase.
Okay, great. Yeah, so actually one of the ones I've been waiting for the most is this 8th point, which I think any agents listening would also be really interested in, which is the late discovery of defects. So, months after the fact, after selling the property, when things come up, what happens then?
Thanks, Will. So having said this, having discussed latent defects, it's quite possible that defects only manifest at a later stage. Like the example that I used with a leaking roof, if the roof doesn't leak, obviously because there's no rain during the winter months, as soon as those summer months come, sort of 5, 6, 7 months later, if the roof starts leaking, that's a latent defect that's only manifested itself later down the line. And that's a late discovery of the defect. The purchaser would still have a claim against the seller. And in actual fact, if the purchaser does identify a latent defect, in terms of civil law, the prescription period of 3 years would apply. So in a situation where this leaking roof started in the summer months on the 1st of September, the purchaser would have 3 years from that date to actually institute a claim in terms of a damages claim or by way of summons against the seller. After the 3-year period, his claim would have prescribed. He wouldn't be able to claim against the seller. Having said that, I think it's also, there is a duty on the purchaser to deal with defects up front. It goes without saying that although there's a prescription period of 3 years, the longer the purchaser waits, the less effective his claim becomes. And I suppose then the seller would have more of a defense at the end of the day. So when these defects appear, it should be dealt with up front as soon as possible, and also to avoid further damage. So if there is a leaking roof or there is some sort of a crack, I think the purchaser also has a duty to mitigate the damages and not to allow it to get worse. So if I was a purchaser and I identified a crack in the foundation and I didn't do anything about it for a year and a half and the crack got worse, then possibly I wouldn't be entitled to my full claim, and the seller would be able to then reduce the quantum of damages as against him. So definitely defects that appear at a later stage, can be dealt with if they only manifest in an early stage, at that stage. But the longer it takes to deal with it, the weaker the claim becomes.
Okay, yeah, makes sense. So we'll move straight to the last point, which I think is very important for all clients, buyers, sellers, everyone entering the transaction, just to be aware, and also for us as agents to also know what the estate agent responsibility is.
Yeah, well, I think as a real estate agent, I think it's in your interests to be aware of latent defects and to have this discussion up front with your seller at the time that you take a mandate, because it's something that you as the agent would need to disclose to the purchaser, and being the seller's agent, it would be your responsibility. But definitely, if there's a defect in the property that has been disclosed to the agent and the agent fails to disclose that to the purchaser, well, definitely then the agent might find himself being a second defendant in an action by the purchaser. And at the end of the day, as an agent, you don't really want that. Having said that, as well, with the Property Practitioners Act that's coming into play shortly, there is actually a duty on agents to have a mandatory disclosure. And besides being legislated, it's good practice for an agent to thoroughly take the seller through the property and identify possible defects, which are then listed in the offer to purchase so that there's no arguments down the line. And of course, then to avoid any liability on the agent's part. So definitely, if there is a defect and the agent had conspired with the seller, then definitely the purchaser would have a claim not only against the seller but as against the agent as well in his personal capacity. And that could be very dangerous for agents. So disclosure of these defects very, very important.
Okay, excellent. Yeah. So I think that pretty much covers everything as far as Voetstoots and the patent and latent defects. which are all very common questions and all commonly misunderstood things within real estate transactions. So thanks so much for all the information, Neil. I think we pretty much covered everything there. And as usual, if anyone has any questions, please feel free to let us know. I know Neil's also always available for any extra questions, and I'm sure we'll likely have him back on for a third episode. And as I said in the beginning, for those who missed it, he was in episode 5 as well, where we discussed timelines and all of that, and been very helpful with some of the information and misunderstandings that people might have when it comes to the legal side of property transactions. So thanks again, Neil.
Always a pleasure. Well, thanks very much for having me.
Cool, so that's pretty much it for today. So don't forget to like and subscribe. There'll definitely be more info like this coming to the channel. And until next time, thanks, guys.
Cheers, Will. Thanks.